Most people think that when they've signed their estate planning documents, they're done. But what about what happens after you're gone? Has your trust actually been funded? What happens to your personal property or that Tupperware collection that your kids might fight over? And if you have a child with disabilities, are you the only one who's thinking about how their inheritance should be handled? These are the types of gaps we see all the time, and they can cause real problems down the line. Let's talk about how to close those gaps. And if you want more clear, actionable tips like these, please join our newsletter. It's full of smart planning guidance that you won't find elsewhere. So let's talk about what happens to your revocable trust after you're gone. There's a process called trust administration. All your assets don't just magically go to the next generation, like with a magic wand. There are steps the successor trustee has to take legally to get those assets to the right people. So please check in with your successor trustee to make sure that they're okay with being named for that role. If you've named a professional as successor trustee, and I often recommend this, check in with them to make sure that they're still fully functioning and ready to take on this responsibility. It can be a good idea to meet with your estate planning attorney and your successor trustee to kind of walk the successor trustee through the trust administration process, let them know what to expect, what hurdles they might need to overcome, that sort of thing. You don't want there to be any surprises. A lot of times gaps come up because there are things that people aren't expecting, and then that's where we run into problems. Another gap that comes up is how assets might be titled in the trust. Is there anything outside of the trust? So I recommend that every year or so you look over all your assets and make sure that they're either properly titled in the name of the trust, or they might be named as beneficiary of your retirement accounts, of your life insurance policies, of your annuities, whatever assets you might have that's being passed down to the next generation. I have a video called Funding Your Trust, which talks about what to do with different types of assets when you have a revocable trust. And for our clients, we now have a trust maintenance program. This is where we do yearly check-ins with our clients to make sure their estate plan is in tip-top shape. It's like going to the doctor for preventative care. All right, another gap often comes up with tangible personal property. Where is it going to go when you're gone? These are the items that are fought over the most, those valuable or sentimental items that are in your house. It's often not the expensive things that cause fights, but maybe it's more the sentimental things like photo albums or your favorite frying pan. What I recommend is that you write out a list of all your different items and the things that you want to go to different people. And then you sign and date that list, and that can be included, kind of attached to your revocable trust. That lets the trustee know which items you want to go to which people. I've seen people put like little tags on the items, but sometimes those fall off. So it's better to have something in writing. And please write it down. If you've promised something verbally to somebody, please write that down, because that could cause a big fight later on if they're remembering that you promised something to them and then they don't end up getting it. They might blame the successor trustee when it's really not their fault. Also, please don't forget about cars. Where do you want your cars to go? Sometimes those are very valuable assets and you want them to go to somebody who can benefit from them, somebody who's not too old or doesn't get into car accidents that much, somebody who you really know could use it.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
All right, so another big gap that comes up is related to healthcare. Everyone who's turned 18 and is an adult and has capacity should have an advanced healthcare directive. This is so someone else can talk to the doctors and access their medical records if they're unconscious or in a coma or they just need a lot of help. Some healthcare directives do not include what we call a HIPAA waiver. This stands for Health Insurance Portability and Accountability Act. So that guarantees a right to privacy for your medical records, and you need to waive that right to privacy. Some forms don't have that waiver, so make sure to take a look to make sure that your form does, or you can sign a separate HIPAA waiver so that your agent can access your medical records. Also, some people want to address that do not resuscitate issue. That's if you flatlined at home and when the emergency medical technicians come over, you don't want them to revive you. In that case, the healthcare directive does not work. It doesn't address that issue. You would need to fill out this hot pink form called a POST form. This stands for Physician Ordered Life-Sustaining Treatment form, okay? And you put it up on your refrigerator, and that's what they look for, or maybe at the end of the hospital bed, and then they don't need to revive you. I have a video on POST forms that I encourage you to watch if you're in that situation. Another gap that I see is not really looking to see who else is involved in your financial life and making sure that everything is coordinated. For example, if you have a disabled child, who might also want to leave money to that disabled child? If you have generous family members out there, make sure to create what we call a standalone special needs trust. So those family members can put in their own estate plan what they want to leave to your child's special needs trust, and it's up and running regardless of whether you died before or after those other family members. If your child's special needs trust is embedded within your revocable trust, then they can only leave money to that special needs trust that you've created if you've died before they did. That's a chance you probably don't want to take. So definitely create a standalone special needs trust that everybody can fund money to. Now, if you're leaving money directly to an adult child, how do you make sure that that money is protected? Well, I usually recommend that you talk to that child about the importance of setting up a revocable living trust. You can even pay the attorney's fees for them to create that trust. But it's super important that you make sure that you don't just leave money thoughtfully to a child and then they have to go through the probate court process. And at a minimum, make sure that all of your adult children have durable powers of attorney and advanced healthcare directives in case anything happens to them. Like if they happen to get into a car accident and you need to take over for them even temporarily. So estate planning isn't just about signing documents. It's about making sure that all the details are handled so that your wishes are actually carried out. If you found this helpful, please check out our other videos on trust funding and special needs planning. And if you would like to talk to our team about your estate plan, click below to schedule a consultation. We're here to help you close those gaps before they become problems.
If this video is helpful for you, share it to someone else who might benefit from it.